Hi everyone. So today we're going to deal with a rather contentious issue that relates specifically again to the city of Johannesburg. So when we all move either into our residences or when a new building gets built, we apply for a tariff from the city of Johannesburg. Invariably, what happens is that an engineer will apply for that tariff from the city, especially when that building gets built in the beginning. And a tariff will get assigned to, let's for argument's sake, it is a large building. An application will get made, and if it is a body corporate, for argument's sake, once the building is built, that tariff will get transferred to the body corporate. And at some point, the body corporate will have to open an account in their name. That tariff remains as a bulk tariff, remains with the account, with the body corporate. It is a NERSA regulation that the tariff must be displayed on the account. For whatever reason, the city of Johannesburg does not adhere to this regulation. So if we now think about it from a practical point of view, the person who lands up paying the account is not the person who did the application originally. So if the tariff is not displayed on the account, there is no way that that person will know whether the correct tariff has been billed or not. It is also, realistically, if you think about it, most of us do not really have the knowledge when we look at an account to discern how the tariffs are made up, and whether we've actually been billed on the tariffs. In real terms, we would assume that whatever agreement has been made with the city, that those are the tariffs that would be billed. I mean, common sense, and one would assume that we all operate from a basis of trust, that if an agreement is signed, that one would adhere to the terms of that agreement. It appears that City Power and the city of Johannesburg deems it fit not to do so. Now, when we now look at the bylaws, the electricity bylaws, there is a clause 9.7, that states that if billing has taken place other than a faulty meter, that it gives them the right to only correct it for only going back for 6 months. However, there are obviously a whole lot of other things that apply, because you cannot blanketly bill somebody incorrectly, benefit from it, and then say, well, we're only going to correct it for 6 months and benefit all the way back as a result of that. But they argue that that is their right and that they can do so. And there are many clients that have been at the short end of the stick. It would be one thing if they applied this bylaw or this rule consistently, but they don't. They do so selectively. And it's not as though they do it applying prescription, which is 3 years. They will do so, once again, selectively. So it is interesting to see or to find out how their minds work and how the rule gets applied, because clients are prejudiced as a result of their behavior. And obviously, it is not, in my point of view, certainly not legal the way that this is done. When we also look at the bylaws, obviously there are other clauses that say that when an agreement is concluded, that agreement cannot be changed. The other clause in the agreement says that whatever agreement is assigned, and the tariff that is assigned, that is the tariff that must be billed. There are other, obviously, acts such as the Public Administration for Justice Act that clearly states that a municipality may not unduly enrich itself through an administrative error. And when such an error occurs, that it must be corrected back to the date when the error occurred. Now, when we look at some court cases and things like that, prescription applies. The problem that I have is that the city appears to, and some of its officials, appear to deliberately engage in this particular behavior. It seems to be that what the pattern is that when an account or when a tariff is assigned, they seem to take quite a long time before the first account is issued. And when that account is issued, invariably it is billed on the incorrect tariff. Most people don't pick it up. And it is not picked up for a very long time. When it is picked up, there's two things that happen. If you are not aware of what is going on, they will try and force you to do an application for a tariff change. If you fill out a form for a tariff change, what it does is it immediately nullifies any chance you have to backdate the tariff to from a correction point of view, because they then say that you have applied for a new tariff and the new tariff only applies from that date going forward because of a new tariff application. So they are quite sneaky in trying to make you do that, make you apply for a new tariff, therefore denying you any chance of getting a journal done and having the tariff rectification done from that point of view. So very careful that if you find that there's an incorrect tariff, that you do not fall for that trick. It obviously is important from a tariff point of view that one needs to verify whether you are on the correct tariff. At this particular point in time, it is very difficult because the tariffs are not displayed, and it is something that we are working on to make sure that that they're starting to adhere to that. With the current administration, it is difficult to see whether that will happen or not. But we can only continue to try. The only other way that one can do that is to actually then physically have a look at your bill and check your tariff application and verify it going through the tariff book. It is not that easy if you're not familiar with tariffs, is to check, because obviously depending on the tariff that you are on, especially if you're a large power user, the only way that you can actually verify it is to physically go and have a look and see whether the rand per kilowatt hour, your network charges, service charges, which sometimes, if you're a large power user, those things are added together to then see if those things add up, to see if that's correct, whether you're a large power user, low voltage, medium voltage, those types of things, whether it actually matches. So it's not that easy. Becomes a little bit easier, perhaps, if you're a residential user, whether you're a 60 amp, 8 amp, single phase, 3-phase user, a little bit easier to detect. It is very difficult to get council to fix these things at present, and they are doing everything in their power currently to not reverse money that is due to residents. The frustrating thing is, as we look at things, and what is interesting is that politicians continue to stand up and say that out of the 80 billion rand budget, there's roughly 40 billion rand due. However, when we've asked for reports, they have not been able to provide us a breakdown of that information. The questions that I have asked is that when we look at the 2018 valuation roll, there's probably, out of that supposed 40 billion rand that is outstanding, I would question and say that out of the 2018 valuation roll, we know that properties were grossly overvalued, and there's a vast amount of money that is still due back to residents out of the 2018 valuation roll. We know that on the 23 valuation roll, properties were also grossly overvalued, and there would also be a vast amount of money due back to residents and property owners on that. It would be interesting to find out of the outstanding queries and credits that are due to clients, what portion of credits are due back to clients and consumers out of the supposed 40 billion rand. Court cases that have not been actioned and that have been ignored, it would be interesting to see what is due back to clients as far as that is concerned. If I just look at 2 simple cases last week, consumer whose water bill is normally about 140,000 rand a month got a water bill for 12 million rand for 1 month. And when I queried it, the consultant at the City of Joburg told me not to panic because an electricity bill for 19 million rand went out. So I mustn't be too surprised. If these types of things are happening, and it seems to be the order of the day, and disconnection notices are going out at the same time, we need to wonder and ask a lot of questions as to the validity of the numbers that are being thrown around by the administration, by the municipal manager, by the politicians, and the type of draconian actions they take against businesses and against residents when it comes to disconnection notices, when they say that there's so much money outstanding. Because what is interesting and what is disturbing is that an account of 12 million rand can be sent out to a client whose normal account is 140,000 rand. How can an account for 12 million rand be sent out? I mean, those sort of practices should not be allowed. And on what basis are those sort of practices allowed? And why are they allowed? And why are there not better controls in place? It is alarming, and it is not unusual, because we know that these things have been going on for a long time. But I think that as residents and as business owners, it is time that we are made aware of it, that it is front of mind, and that we make sure that from an administrative point of view, that we are cognizant of these things, and that we make sure that we make the right decisions, that we put an end to it. Please take care of yourselves.